ukiweka mahali hivi inakauka. Sasa ikafikia wakati uende utengeneze bed.
It's a very vital plant in our bodies, in our homes, in the community, and also we are extending it in the country.
Indigenous seeds play an essential role in food production, food and nutrition security, and by extension, in the realization of the right to food.
Tulikuwa vimepotea, lakini sasa vimerudi.
Mbegu yetu, haki yetu, asili yetu.
The indigenous seed system, commonly known as the Farmer Managed Seed Systems, FMSS, thrives largely on seed saving, sharing, and exchange, which forms a part of cultural practices from different ethnic groups in Kenya.
Farmer Managed Seed System is a system of where farmers can freely share, save, multiply, and even exchange or sell their seeds.
The ability of smallholder farmers to freely save, share, exchange, and sell their farmer-saved seeds, also regarded as seed sovereignty, is recognized as part of farmers' rights under Article 9 of the International Treaty on Plant Genetic Resources for Food and Agriculture, ITPGRFA, to which Kenya is party since 2003.
Here we talk about farmers having their right to save their seed. There have been many challenges in the country where farmers have been seen not to be breeders or people who can save their seed or share their seeds. But now with Kenya as a signatory and our constitution being very strong in terms of indigenous seed, we are very happy with the recent win. On November 27th, BIBA Kenya, the Biodiversity and Biosafety Association of Kenya, and other partners that we've worked closely with, went to court some 2 years ago, where we were seeking a constitutional interpretation of our Seed and Plant Varieties Act vis-a-vis our constitution.
In a landmark judgment delivered on November 27, 2025, the High Court of Kenya struck down punitive sections of the Seed and Plant Varieties Act, declaring unconstitutional the laws that had criminalized the saving, sharing, and trading in indigenous seeds.
A case was filed by a number of farmers in Machakos County. The case was brought before the Machakos High Court. It had the first interested party as Greenpeace Kenya, and we represented Biodiversity and Biosafety Association of Kenya, which joined this case as a second interested party. The key questions that were being raised in the petition was that, firstly, provisions in this new amendment introduced offences in which farmers could be arrested for selling, exchanging of seed, and they were not either registered as seed merchants, or these seeds were unindexed. And as we would come to realize, majority, if not all, indigenous seeds are not indexed, and they're exchanged by the ordinary farmers in Kenya, indigenous farmers in Kenya, or what would be protected under the law as peasant farmers.
Through the court, the High Court within Machakos, the ruling that was made, they were able to declare a few clauses unconstitutional. An example is clause 3D and the seed and plant varieties regulations that were made in 2016. These were clauses within the constitution that really affected our farmers. It really affected their ability to save their seed, because many of the farmers were very scared, or they were afraid of the fines and the jail terms that had been imposed on them in case they were found with selling uncertified seed. But what we've come to notice when we go to the ground, because we've been working with a lot of farmers over the years, this journey of our seed sovereignty, we did not do it alone. We did it in collaboration with our farmers on the ground. These are women, youths, and men who have been waking up every day to be the seed custodians of Kenya. People who wake up in the morning to preserve our seeds, plant them, regrow them, and share them.
Delivered by Honorable Lady Justice Rod Ruto, the ruling restores the full rights of farmers to manage their own seed systems, rights that had been eroded by regulations favoring multinational seed giants while imposing crippling penalties on ordinary farmers.
Sasa tumefurahi sana, tumeshukuru serikali yetu pamoja na mahakama sababu imetupatia uhuru wa kupeana hizo mbegu kwa marafiki zetu, kuziuza, kusipatia watu wengine ili hawako waende wafumade. Tena tukiangalia zimetupatia manufaa mingi kwa sababu mafuno imekuwa mingi. Zilikuwa zimetushika. Ni kama vile tulikuwa tumeshikwa mikono. Tusipeane hiyo kitu ile kizuri, hiyo mabegu zetu ya viazidi. Tuendelee na hizi zingine. Lakini tumefurahi sana na mahakama yetu.
Baada ya ruling court on 27th, tuliweza kuwa na shangwe na vigerengele kwa maana tuliweza kufunguliwa pingu ambazo tulikuwa tumefungiwa. Sasa tuna wakati sasa wa kushare, wa kubadilishana, wa kuuza, na sasa kile sasa tunahimiza zaidi sasa uhuru sasa wa kupewa. Tuwe tu brand bengu zetu, tuwe tunaziweka bengu zetu, tuziweke kwa makaratasi, package kama vile Duma zinakuwa na package. Ukienda kwa Pioneer utakuta ziko packed, ziko na namba, ili tukaweze kuziweka kwa shelves.
The highly celebrated ruling effectively decriminalized the traditional practices of saving, sharing and exchanging the indigenous seeds by smallholder farmers.
Kuna wakati nilienda mpaka huko Machakos kwa sababu ya kusikisa hiyo kesi. Ilikuwa mapambano. Na hiyo mapambano baada ya kupambana tarehe 27 mwezi wa 11, nashukuru Mungu sababu hiyo mapambano tulipambana na tukashinda. Na hiyo kushinda kwetu ni kumaanisha ni tulime kwa bidii. Haya, hiyo vitu tunalima vile mahali tumefikia, tuwe huru. Zile walikuwa natuuzia yao 800 ama 1000, nasi tuwe huru. Nasi tuanze kuwauzia kwa sababu hii zetu hazitaisha nguvu, hazitatoka market. Kama hazitatoka market tangu enzi ya wazazi wetu walipokuwa na kuwa mababu zetu, ni wakati huu itaisha market.
A group of 15 smallholder farmers supported by civil society organizations like Biodiversity and Biosafety Association of Kenya, BIBA Kenya, and Greenpeace Africa filed a case in 2022 challenging the constitutionality of certain provisions in the Seeds and Plant Varieties Act of 2012, which imposed heavy fines of up to 1 million Kenya shillings and potential jail term of up to 2 years for using, sharing or selling uncertified seeds.
The problem was it introduced specific provisions that not only criminalize farmers who used, sold or exchanged these indigenous seeds in a manner that was not provided for under the law, but it also introduced provisions that were considered as violative or threatened to violate the rights of farmers who are used and exchanged these indigenous seeds.
These regulations were seen as favoring commercial interests and corporate seeds over traditional, locally adapted varieties. The petitioning farmers also argued that the act violated their constitutional rights, including the right to culture, food security, and the protection of indigenous seeds, which form part of their cultural heritage.
The impact of this particular judgment to farmers is the laws that were in place to either criminalize them, to limit the way they would exercise their right to food and their right to culture and exchange in seeds has been struck down as being unconstitutional. Therefore, we revert back to what usually happened in the past. So if indigenous seed farmers could exchange, sell and use the seeds without going through these hefty procedures, they are allowed to do so. And it protects the seed sovereignty and the general food sovereignty in the country.
The court now favored us. Now we have our rights. Let's put it now on ground, implement it to show the world that our seeds indeed can produce enough food for the world.
This determination continues to shape a long legal battle that centers on a protracted conflict between commercial agricultural interests and traditional farmer practices.
Our constitution is very strong in the protection of traditional knowledge, indigenous seeds, indigenous knowledge systems. But our Seed and Plant Varieties Act was very restrictive in terms of favoring commercial interests or commercial companies who have the resources and can produce seed. And a lot of this genetic material is obtained from the farmers, maybe a little done on them, and then they are sold to them at a high price. And so when we went to court, we are happy that on the 27th of November 2025, the High Court in Machakos gave a ruling, and all the clauses that we showed were negatively impacting smallholder farmers were removed or were considered to be removed from the Seed and Plant Varieties Act to protect smallholder farmers who have been the custodians of seed, who have fed us. We're not saying that we do not want proper sanitary and phytosanitary standards, but the farmers' rights to be considered and their voice, because they have been feeding us and they have access to all this genetic material. Their rights should be considered as paramount and very important.
Food security and climate resilience depend heavily on diverse, locally adapted indigenous seeds, highly cherished by many as the library of life, and hence criminalizing their use erodes this vital genetic diversity and threatens the food sources for the majority of the population who rely on these systems.
Ili to prepare for the next planting kwa nursery, tuweke kwa nursery, ndio sasa tuweze kutransplant.